everyone, welcome back to the Outside the Courtroom series. Today's presentation is titled Of Gaudy Earrings, Bare Arms, and Revealed Cleavage, the Feminine Face of the Ills of the Bar. And you're welcome aboard. So, literature in English was my favorite subject in both my O and A level classes at St. Monica Secondary School in Asante Mampo. Apart from the richness it added to one's language, literature in English also gave a vivid historical account of how people lived during various epochs of human civilization. I loved the African Writers series, but Shakespeare was also a favorite, and I followed his writings with keen interest. Now, one of our select books for drama at A level was Hamlet, and I thoroughly enjoyed it. Very early in the book, young Hamlet gave his mother Gertrude a dressing down in his first soliloquy. Apparently, Gertrude's offense was that she had married Claudius, her late husband's brother. "Frailty, thy name is woman," Hamlet famously declared. When Hamlet later met his mother in her closet, his words were even more scathing. Even at that early stage of life, my 17-year-old brain got shifted into fifth gear as I started asking myself a lot of questions. There were questions about Hamlet's rude attitude towards his mother. Why wasn't Hamlet angry at Claudius, who married his mother Gertrude, but rather he vented his spleen on Gertrude, who most likely did not have any choice in the matter? Why did Hamlet bundle all women together and describe them as weak on account of his perceived weakness of one woman, his mother? And so on. These were the questions going on through my mind. And to my eternal surprise, though Hamlet could blast his mother with words that felt like daggers in her ears, he failed to find similar strength to accomplish the task his late father's ghost had set down for him. Hamlet could not avenge his father's death, but he had enough time and words to berate his mother, whose only crime was her marriage to her late husband's brother. Thus was the beginning of my appreciation of gendered perspectives and stereotypical attribution of problems to women, when we have no practical solutions to the real problems that confront us. Female lawyers and judges under the radar. On Tuesday, 15th September 2020, the Ghana Bar Association held its virtual annual conference from the auditorium of the court complex here in Accra. The conference was originally scheduled to be held in Bolgatanga, but for the COVID-19 pandemic. As is the tradition at the bar's annual conference, the virtual conference was reportedly addressed by the President of the Republic, the Chief Justice, the Attorney General and Minister of Justice, and the President of the Ghana Bar Association. The theme for the conference was, and I quote, "Enhancing National Cohesion, the Essence of Free, Fair, and Responsible Electoral Process." Of all the speakers who addressed the conference, none appeared to have received much coverage in the press than the President of the Ghana Bar Association. The Ghana News Agency reported in a publication titled "Refrain from Showing Too Much Skin, GBA President Warns." And this publication was put on Ghana Web, and it was to the effect that the bar president had said that whether in court or at the office, lawyers and judges should refrain from showing too much skin. He is quoted to have said that, and I quote, "Bare arms are generally frowned upon in the office and never appropriate in court. Skirts and blouses should always be bottomed so that cleavage is never revealed. Bare legs are never acceptable in court, and neither are open-toe shoes. Anything flashy, such as large gaudy earrings or sandals, are also inappropriate. He also reportedly added that the legal profession remained one of the most conservative concerning work attires, and that hair and makeup should also be conservative. The bar president is said to have added that female lawyers should wear dark suits with trousers or knee-length margin skirts. The next day after the Ghana News Agency publication, which I've just referred to, other media houses published the story with such repugnant headlines that I shudder to repeat here. Now, folks, the speech as published and attributed to the bar president left a lot to be desired. It was most condescending, sexist, and betrayed the persistent patriarchal narratives that still feature in our discourse even in this 21st century. Whenever it suits our whims, we take umbrage under the so-called conservative nature of our profession and rebuke others for no apparent reason other than sexism and discrimination. Whose sense of conservatism are we protecting? Is it that of the British or the Ghanaian? The British, whose legal system was imposed on us in 1876, have since moved away even from the prescribed apparel of old. They do not wear tailcoats to court. Throughout Ghana, every lawyer who goes to court must necessarily cover their heads and body with wig and gown. How then do female lawyers and judges appear in court with disheveled hair, bare arms and legs, and revealed cleavage, while covered in wig and gown? As for the female lawyers and judges who wear large, gaudy, whatever that means, earrings, flashy makeup and sandals, if not for medical reasons, to court, we need to await specimen from the speechmaker. Apart from wearing the usual dress, skirt, or a pair of trousers, one cannot see how else female lawyers and judges can completely avoid exposure of parts of their body. The admonition, as issued, transcends female lawyers and judges dressing in court. It applies with full fall and effect to their dressing in their offices as well. The last time I checked, lawyers in their offices, both male and female, wore normal office attire. Some even have Friday African wear policy in place. There is nothing wrong with that. Choosing to prescribe what female lawyers and judges should wear, even in their offices, with all due respect, is distasteful, chauvinistic, and discriminatory. It is interesting to observe that in the past 12 years, when we had female chief justices, there was no complaint about how female lawyers and judges dressed. In just the few months since the last female chief justice retired, the front burner issue for the Bar Association then became how to get an imaginary, scantily dressed female lawyer or judge to cover herself up. At any rate, a president of the Association of Magistrates and Judges of Ghana cannot chastise members of the Ghana Bar Association any more than a president of the Ghana Bar Association can drag the name of a section of the Association of Magistrates and Judges of Ghana through mud. As a profession, we've hidden behind an affinity with conservatism to stifle our own growth and development, while society has passed us by. Admittedly, our profession is a noble one, and we need to carry ourselves in a manner that befits our calling. However, it will be most unreasonable for one to expect a lawyer practicing in Ghana today to dress like a John Mensah Saba or an Annie Jage. These two pioneering stalwarts of our profession belong to their time, and so do the present generation. In the days of Mr. Saba, it probably would have been heresy for a male lawyer to be seen wearing happy socks or figure-hugging suits. These days, we have them in fashion and we love them. In the days of Mrs. Jage, Brazilian hair was most likely to be found on Brazilian heads. Nowadays, We rock them over our kinky hair and we love them. Much as members of the bar and the bench are keen to abide by the reasonable dictates of the ethics and code of conduct of the legal profession, it does not lie in anyone's mouth to isolate the female section of the profession and hold it to public scorn and derision. Now, let's look at some of the challenges that need to be addressed by the Bar Association. After all is said and done, there are real challenges confronting the legal profession today. And as a profession, we cannot just sit in a corner and suck our thumbs while waiting for the next ritualistic annual conference to come round. We need to find space and time to address those pertinent issues. 1. Law school admissions. The foremost challenge confronting the legal profession in recent years is the law school admission process. Matters came to a head when a citizen put the issue before the Supreme Court. Though the Supreme Court and Parliament subsequently addressed aspects of the law school admissions process, the efforts appeared to have yielded little result. The situation was not made any easier by a Chief Justice who maintained that for as long as she had anything to do with legal education, there will be no mass production of lawyers. No definition of mass production accompanied the edict so issued, but the meaning became clear when in the 2019-2020 academic year, only 128 out of 1,820 students who sat for the law school entrance examinations passed and were admitted to the Ghana School of Law. That means a paltry 7% of all potential law students with LLB degrees in Ghana was admitted. Only 7%. Some of the law students even reportedly declared a red week of demonstrations to register their protest against what they saw as a deliberate attempt to restrict entry into the legal profession. In the midst of all the hullabaloo, the Bar Association's silence was most deafening. We chose to be silent, lest we ruffle some pristine peacock feathers. As the Venerable Archbishop Desmond Tutu once wrote, if you are neutral in situations of injustice, you have chosen the side of the oppressor. If an elephant has its foot on the tail of a mouse, and you say that you are neutral, the mouse will not appreciate your neutrality. The late Margaret Thatcher it was who once advised that standing in the middle of the road is very dangerous. You get knocked down by the traffic from both sides. In the past, our association was the conscience of the nation. The sad thing is that even as the Bar Association has adopted the mom stance, the law school entrance saga remains a dominant national issue. Indeed, so central is the issue that a political party included it in the party's manifesto in the 2020 national general elections. Now, recently, when the results of the 2020-2021 academic year law school entrance examination results were released, it was at once shocking and relieving. It was shocking because 1,045 out of 2,720 students who wrote the examinations passed and gained admission to the Ghana School of Law. It was relieving because for the first time in several years, many LLB graduates had the chance to undertake the professional law course. Interestingly, nothing much has changed in the physical infrastructural fortunes of the law school in the past year, but there has been such a quantum leap in admissions. Perhaps if we had added our voices to the call for expanding access to legal education when it mattered most, maybe, just maybe, relief may have come a tad earlier. It is not late still for us to show interest and commitment in the affairs of the school that provides the membership of our association. Apart from the law school entrance saga, the second issue that should be of importance to the Bar Association is enforcing the provisions of our association's constitution and regulations. Now, in 2000, the regulations of the Ghana Bar Association mandates the General Council of the Bar to do the following. 1. To arrange the professional training course for lawyers in Ghana. 2. To register foreign qualified lawyers to practice in Ghana. 3. To organize the call of lawyers to the bar. 4. To fix annual subscriptions for Bar Association membership. 5. To register all professional chambers. 6. To enforce disciplinary measures for professional misconduct under the Code of Ethics, and so on and so forth. We need to ask whether, as an association, we've been fulfilling our mandate under the GBA's constitution and the regulations, as I've stated earlier. To my mind, the third issue that the Ghana Bar Association needs to look at is the e-justice system. Now, in 2019, the e-justice system was formally launched by the President of the Republic, signaling the end of the old manual justice delivery system and its attendant problems. The euphoria that greeted the launch has, however, given way to disappointment because nothing much has changed. We still carry processes physically to court and file, among other frustrations, which we thought the e-justice system would have wiped out. The fourth issue that the bar needs to pay attention to is the effect of the COVID-19 pandemic on the legal profession. Last year, the COVID-19 pandemic changed the nature of our profession and law practice for good. Globally, most lawyers' livelihoods and businesses, just like all facets of life, took a hit, and we need to advise practical ways to weather the storm till calm is restored. The Bar Association's role in this endeavor will be very crucial. So these are some of the pertinent issues that ought to engage our attention as an association. As an association, our time will be better served in addressing some of these issues that I've raised, rather than engaging in our favorite pastime of tickling the ears of some retiring judge with ill-deserved panegyrics. So yes, the Bar Association has challenges, and when we look diligently, we will find that the challenges go beyond the length of a female lawyer's skirt and the blush on her cheeks. Thank you so much for watching and for listening. And I encourage you to share your comments in the comment section so that at the end of the day, we will all learn from each other and share our views. Thank you so much and see you next week. Bye for now.